Mr. Longstreet, on direct examination, you testified that you calculated that your park was losing $750 per day because of some wristband scheme.
Well, that's what we calculated on average, yes.
You also prepared an affidavit for today's case.
Well, yes, I did.
You were told to include anything that you would testify about today in court.
Well, yes, sure.
So of course you did so.
Yes.
Now approaching opposing counsel with the witness's affidavit.
What line will you be referring?
Your Honor, we're referring to the document in its entirety. Now approaching the witness and showing the witness the same. Mr. Longstreet, that's your affidavit, is it not?
Yes, it appears to be.
It's a fair and accurate copy of that document.
Yes, it looks like it.
And you included everything in that document that you would be testifying about today in court, right?
Well, I wasn't sure exactly what I would be testifying about,
You
so
knew
I
you-
did my best.
You knew you would be testifying about some wristband scheme.
Well, yes.
So of course you would include how much you think you were losing per day in that affidavit.
I mean, I did the best I could.
And if you turn to the last page,
All right.
that's your signature,
Yes, it is.
and you realize that you're under oath today in court.
Of course, yes.
Could you please tell the court where in that affidavit you said that you're losing $750 per day based on your calculations?
It's not in this document. However, it is in the documents that I was familiar with, and that I used the documents to come to that conclusion.
You didn't write that conclusion anywhere in any of today's relevant court material.
No, I didn't.
And you knew you were going to be testifying about it.
No, I didn't know what exactly was going to be coming out.
You knew you were going to come testify about a wristband scheme,
Well, sure, yes.
and you didn't think that you were going to testify about how much your park was losing per day?
I wasn't sure, no.
So just to be clear, you didn't include that in your affidavit.
No, it is not in there, no.
You also said that you saw Whit Bowman at the Tunnel of Terror on August 30th, 2012.
Yes, that's right.
That's extremely relevant information to today's case.
Well, when I wrote the document, I was not sure.
Directing back to my question, that's extremely relevant to today's case.
Well, I suppose it is.
And you were told that you could change this document up until the moment before trial began.
Yes, that's correct.
And you were told to include anything relevant and pertinent in that document.
Yes, that was what I was instructed to do.
You were told to include anything that you might testify about today in court.
Yes.
Could you please tell the court where in that document you say you saw Whit Bowman operating the Tunnel of Terror on August 30th, 2012?
Well, it's not explicitly in here. However, I do state
Mr.
that I was
Longstreet,
at...
directing you back to my question, could you please direct the court where in that affidavit you included you saw Whit Bowman operating the Tunnel of Terror on August 30th, 2012?
It is not
It's not in there.
explicitly in here.
Approaching the witness and retrieving the document. Now, your employee, Winston Thomas, was struck by the Tunnel of Terror on August 30th, 2012 and died that night. Is that not true?
Yes, that is correct.
Let's talk about the safety of your park a little bit. Your park's not the most safe in terms of the rides, is it?
Some of the rides are older, yes.
Directing back to my question, your park's not very safe, is it?
I wouldn't say it's not very safe.
You know that you have a reputation for having an unsafe park.
Well, here and there, some people say that.
So that's a yes to my question?
Yes.
And in fact, you cut corners in terms of safety to gain a higher revenue.
Well, to cut corners, is to save on the expenses here and there.
Is that a yes to my question? You do cut corners in terms of safety to gain a higher revenue?
Yes, well, occasionally.
And if you would have had a safer ride, maybe Winston Thomas wouldn't have been killed on August 30th, 2012.
Objection, Your Honor, improper opinion.
This is the owner of Rock Rules Amusement Park. He knows that rides could have certain safety measures that could, in fact, deter a ride from killing somebody. And he said he's cut corners in terms of safety. This is extremely pertinent to today's case. This is the state's own witness.
If I may, Your Honor. He asked Mr. Longstreet if you had a safer ride that would have prevented Winston Thomas from dying.
Did not
He
ask-
cannot.
Did not ask that. It's possible that Winston Thomas would not have died on August 30th, 2012, was the question.
Mr. Longstreet, he cannot possibly know that information.
I think he's asking for his opinion as to the ultimate theory of the case. So I'm gonna overrule it. He's the park's owner and testifying, he also testified to, surprisingly enough, that he wants some corners in his own business, which I didn't see all at the same time, but since it's already been testified
Yes, Your Honor.
It's possible if you would have had a safer ride that Winston Thomas might not have died on August 30th, 2012.
It's possible if Whit Bowman had not been operating that
I'll direct
route.
you back to my question, Mr. Longstreet, if you would please just answer the questions that I asked. It's possible that you would have had a safer ride, the Tunnel of Terror, that Winston Thomas would not have died on August 30th, 2012.
I can't possibly know that.
Now, you also have a reputation of using purchasing power upon those in high places in Midland's Police Department. Is that true?
Purchasing power?
It's a word you used in your own affidavit, is it not?
The way that it is. it's
Directing back to my question, you used the word purchasing power in your affidavit.
Objection, Your Honor. Argumentative.
It's argumentative, at this point, that's overruled, but you've asked the question, you gotta live with his answer, so he's asking you regarding whether you use the words purchasing power. Yes or no question, go ahead.
Did you use the word purchasing power in your affidavit?
I did use that word, yes.
And you have a reputation for using your purchasing power upon Midland's finest.
Objection, Your Honor. Relevance.
Your Honor, opposing counsel has testified that Detective Kimball in today's case as being the state's lead investigator, the detective who conducted the interrogation and arrest of Whit Bowman. If allowed to continue with this line of questioning, we will show this witness's bias and Detective Kimball's bias.
You're gonna show Detective Kimball's bias through him?
Yes, Your Honor.
What do you have to say?
This witness's connection to the police force, whether he has a purchasing power that is corroborated to the police force, doesn't make any fact in this case more or less probable.
Your Honor, may we be heard?
No, at this point, I can't really rule on a relevance objection because I have absolutely no idea what purchasing power means or what theory it is that you're talking about here. So if you want to explore that theory a little bit more, it might become relevant if you have some alternate theory of this witness using his ability to bribe a police officer. Well, you're going to have to get a little more foundation if I'm going to allow something like that, okay? So at this point, I'm going to sustain the objection and let you continue on with the purchasing power line of questioning to establish a little more foundation. Okay.
Move to strike testimony that may have been elicited, Your Honor.
That's denied at this point. I just wanted to move on with this line of questioning. Go ahead.
You used to employ Detective Francis Kimball at your park, Rockville Amusement Park.
Yes, years and years and years ago, before he was ever on the police force.
You've known the state's lead investigator for years.
Well, yes, it's a small town here in Midland.
I'm not asking about if it's a small town. It's a yes or no question, Mr. Longstreet. You've known the state's lead investigator for years.
Yes, ever since he was a child.
You've known the state's lead investigator since he was a child.
Sure.
And you employed him when his mother was going through a hard time.
Yes, that's right.
Objection, Your Honor. Relevance.
Where are we going with this line of
Your Honor,
questioning?
for what?
Are you now using this witness to try to somehow impeach opposing counsel?
Not opposing counsel, Your Honor, the state's lead investigator that conducted the arrest of my client.
Then let's use that word, because you're pointing at him and saying state's lead investigator. You mean Detective Kimball?
Yes, Your
Is
Honor.
that who you're talking about?
Yes, Your Honor.
Okay. Again, you're using this witness to impeach a witness I don't even know if I'm gonna hear anything from. So it's sustained at this point. What I was discussing was the purchasing power. I still don't even know what that means. Okay, so I have to sustain the objection. Sit down.
Whenever a member of Midlands Police Department comes to your park, you make sure they get VIP treatment.
Yes, with them or any of my friends, complimentary upgrades from our standard admission to the World Tour Pass. It's something I would do for anyone I know.
And you know all the members of the police department in Midlands?
I wouldn't say I know all of them.
But whenever they come to the park, they get your VIP treatment.
Certainly.
And you do the same for Detective Francis Kimball.
Well, yes, I suppose anytime anyone knows them around the park, sure.
Let's talk a little bit about Detective Francis Kimball. You saw him on August 30, 2012,
Yes, that's right.
and you saw the state that he was in,
The state that he was
the
in?
state of emotion that he was in.
Okay, sure, yes.
You saw him at the Tunnel of Terror on August 30, 2012.
Yes, that's right.
You saw him standing over the body of Winston Thomas.
Yes, he had been hit by the ride.
Winston Thomas had been hit by the ride.
Yes, that's correct.
We'll come back to that. Let's talk a little bit about these wristbands that supposedly were fraudulent in the park in the summer of 2012. You don't even know if there was a wristband scheme going on at Rock World in the summer of 2012.
I do know that.
You don't think there are any other possibilities?
I'm sorry, I'm not understanding the
You
question.
know there was a wristband scheme going on in the summer of 2012,
Well, that's what I was informed of.
but you don't know that.
I'm sorry, I'm really confused by your question.
You don't know that there was a wristband scheme going on at Rockville in the summer of 2012.
In terms of, that's what was causing our problems, I can't be certain, no.
You never saw any fraudulent wristbands.
I can't say I spend too much time around the park, like actually inside of it, around the rides. I spend most of my time in the office actually handling the business side.
So did you ever see any fraudulent wristbands?
Well, no.
You were never given any fraudulent wristbands.
Well, no.
And you certainly did not see any fraudulent wristbands with my client, Mr. Whit Bowman.
No, as I said, I'm not usually out in the park. He's a ride operator, he works in that, in the park itself.
Now, let's talk about back to August 30, 2012, when you saw Detective Kimball standing over Winston Thomas. It looked to you that Detective Kimball was in an emotional state.
Yes, I think anyone would be. He was standing over the body of a person that was just struck by a moving ride.
He was standing over a body of a person who he had known for years.
Objection, Your Honor. Speculation.
We're not testifying to the mindset of any individual. If this is rationally based on the witness's perception, he can testify as such. If he doesn't have knowledge on the matter, he can say he doesn't know.
Well, why don't you ask him if he's known that person for many years? It's the same.
Did Detective Kimball know Winston Thomas for many years?
I believe they had known each other from being on the police force.
And prior to that, even?
I'm not familiar with their exact background, but somewhere along the line, yes.
And it looked to you at August 30, 2012, that Detective Kimball was visibly shaken.
Yes, as I said, he was standing over the body of a person that had just been struck by a moving ride.
So Detective Kimball was visibly shaken.
Yes, I suppose he was.
It looked like to you he might have even been crying.
Well, yes.
Objection, Your Honor. Relevance.
What's wrong?
Your Honor, less than an hour later, that detective arrested my client, Mr. Whit Bowman. This is extremely relevant to today's case. It shows a bias in the state's lead investigator, Detective Kimball, and it goes to the validation of the arrest. It's extremely relevant. It makes the fact that Mr. Bowman was involved in these crimes far less likely,
Because he was crying and someone gets struck by it.
because the state's lead investigator who arrested my client, Whit Bowman, was crying. He arrested him less than an hour after this incident.
What else do you think?
Your Honor, you're not going to be hearing from the detective in this case, Francis Kimball. And Francis Kimball, his conclusions aren't going to be heard in today's trial. Opposing counsel is trying to disprove someone's conclusions you're not even going to hear about.
Your Honor, may we be heard?
Sure.
This witness has tried to testify to Detective Francis Kimball's conclusions. Simply because the state did not call him does not mean that his conclusions and his actions are not relevant. He arrested my client, Whit Bowman, on August 30, 2012, and Whit Bowman has been sitting in jail ever since.
Which, okay, I'm failing to see, however, the connection you're trying to make between him crying about this witness, this person who was struck, and your theory of the case. And again, I'm gonna go back to what I said before. I still have no idea what this witness meant by purchasing power. You still have not defined that for me. I don't even know what your theory is. I'm having a hard time following, so it's sustained at this point.
Your Honor, are
It's
this
sustained at this point. Move on.
Detective Francis Kimball said to you, Bowman needs to pay for what happened to Winnie
Objection,
on
Your
that
Honor.
ride.
Relevance.
Relevance?
And hearsay, Your Honor.
Okay, what's
We're
your
not,
response?
Your Honor, we're not using this for the truth of the matter asserted, that Bowman needs to pay for what happened to Winnie on the ride. We do not believe that he needs to pay for what happened to Winnie on the ride. We believe he's the wrong man.
Well, I don't know that it's quite the truth of the matter asserted to your belief, but perhaps what you're using it for is the truth that those words were spoken. correct?
Yes, Your Honor, that's not the truth of the matter asserted. If we may proffer a copy of the Midlands Rules of Evidence, hearsay is defined as an out-of-court statement being used for the truth of the matter asserted within that statement.
I understand what hearsay is. However, what this witness is about to testify to is what? That he said certain words out loud that he heard, correct? Certain words that this man needs to pay, is that what the?
That we're not using for the truth of the matter asserted. Yes, Your Honor.
What are you using them for?
The effect on the listener, the impression of Detective Francis Kimball at that time and his motives.
The effect on what listener?
On this listener, J.C. Longstreet, his subsequent actions testifying in today's court, and Detective Francis Kimball himself in the arrest of Whit Bowman on August 30th.
Subsequent actions of him to then go arrest that person?
No, Your Honor, the subsequent actions of this witness who's testified in court today, his beliefs that he's based many of his conclusions on Detective Francis Kimball's investigation, as you've heard, and the arrest of Whit Bowman that occurred on August 30th, 2012.
What else do you have to say?
They are using it to prove the truth of the matter asserted, that Francis Kimball wanted that individual to pay.
No, that's not the truth of the matter asserted. It's that Whit Bowman needs to pay for what happened to Winnie on that ride. We do not believe Whit Bowman needs to pay for what happened to Winnie on that ride.
It's
Move to strike the testimony, Your Honor.
May we ask that the court give judicial notice that we are not using this for the truth of the matter asserted, so it is not a hearsay statement?
You can ask, but that's no. I'm not gonna take judicial notice of something that I just sustained as an objection.
You stated that Haley Floyd was robbed on August 30th, 2012 by Knife Point.
That is what happened.
Haley Floyd told you that it was Cameron Poole who robbed her by knife point.
Yes, that's right.
Cameron Poole robbed Haley Floyd by knife point without Whit Bowman.
I do not remember hearing anything about Whit Bowman at the time.
So is that a yes to my question?
Yes, I don't remember anything about that.
Haley Floyd said that Cameron Poole had a knife.
Yes, that's right.
She did not say that it was Whit Bowman's knife.
No, he really didn't say anything.
He said that it was Cameron Poole.
That's,
Objection, Your Honor. Asked and answered.
The witness just said he didn't say anything.
Hold on. It's not asked and answered because I don't know what you're talking about at this point. I think we're mixing positions. He, she. Haley is a she?
Haley Floyd is a he.
Is it he? Okay. I've heard she and he at this point. So just ask your question again. Sit down, ask your question, the same question again, please.
Haley Floyd said it was Cameron Poole who robbed her.
yes, that is right.
Haley Floyd did not say that Cameron Poole used any instrument of Whit Bowman's.
He did not say anything about that, no.
Haley Floyd did not say Whit Bowman was anywhere near the robbery.
No, he did not say that.
No further questions.